In a medical malpractice case, is there any benefit during the course of a pretrial deposition for me to ask your doctor whom you believe screwed up, "Doctor, why did you screw up? Why did you violate the basic standards of medical care?" You want to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is no, there is no benefit, zero benefit, for me to actually ask the doctor, "Hey doctor, why did you screw up? Why did you cause my client injury?" You know why? I'll tell you why. Because the doctor will get very defensive from the moment I ask that question. The doctor is always going to say, "What are you talking about? I didn't screw up." So, although you may believe in your heart of hearts that yes, your doctor was careless, that he violated the basic standards of medical care, the doctor, during the course of a pretrial question and answer session known as a deposition, lawyers also call it an examination before trial, the doctor whom you have sued, is not, under any circumstance, going to admit that he screwed up. If he did, half of your case would be over, or I should say a third of your case, right? Because in these types of medical malpractice cases, we have to show that we are slightly more likely right than wrong than what we are claiming is true. That number one, the doctor violated the standards of care and, as a result of that, caused you significant harm and injury. If the doctor were to go ahead and actually admit that he screwed up during the course of the deposition, terrific. Half your case is over, and now we only have to show that the doctor's carelessness was a cause of your injury. It doesn't have to be the cause, it only has to be a cause, and that your injuries are significant and or permanent. So why would I go ahead and ask the doctor, "Hey doctor, tell me why you screwed up"? He's going to get argumentative with me, and first thing he's going to say is, "Hey, what are you talking about? I didn't screw up. No matter how much you and your client believe I did not screw up." And then he's going to say, "Listen, even if I did screw up, whatever I did not cause your client's harm and injury." So that's known as causation. We claim that the doctor's carelessness was a cause of your injury. The doctor is always going to turn around and say, "What are you talking about? Even if I did something that was careless, that was negligent, my carelessness did not cause your client's injury." And then, to top it all off, the doctor's then going to turn around and say, "Listen, even if I did something that was careless and my carelessness caused your client injury, your injuries really aren't as bad as you make them out to be." So the doctor is then going to do everything possible to claim that your injuries are really not as bad as you make them out to be. He's going to try and minimize the extent of your injury. So those are the typical defenses. Oh, wait, there's one more. The doctor is also, if possible, going to try and turn around and blame you, the patient, the injured victim, that you were responsible for causing and contributing to your own injuries. So he'll say, "Listen, maybe I did cause this patient harm. Maybe I was careless. But guess what? The patient failed to do what I told her to do, and as a result of that, she now caused most of her injuries." So he's going to turn around and point the finger at you, the injured patient, the injured victim. And that is the typical defense. Those are the typical defenses that we see in these medical malpractice cases. So a deposition, you should know, is an opportunity for me to ask the doctor many, many questions about what he did and why he did what he did. It's also an opportunity for me to ask the doctor what the standard of care was in your particular scenario. "Doctor, in a patient who presents with X, Y, and Z, would you agree it's important to take a detailed, thorough history?" "Yes, I would." "Would you agree it's important to record that history?" "Yes, I would." "Would you agree, doctor, that after taking a detailed, thorough history, it's important for you to perform a physical examination?" "Yes, I would." "And as a result of that physical examination, it's important for you to document your findings. Isn't that correct?" "Yes." "And would you agree, doctor, that a failure to obtain a detailed, thorough history would be a departure from the standard of care?" The doctor has to say yes. "Okay, doctor, would you agree that failing to do a physical examination would be a departure from the standard of care?" "Yes, I would." My goal is to try and get the doctor to tell me what the standard of care was for your particular situation. The doctor is never, ever going to turn around and actually admit that he screwed up. So trying to ask him, "Why did you screw up?" is not an effective way to go ahead and get the answers that I need. Once the doctor establishes for me what the standard of care was, now I can go ahead and specifically ask him questions about the treatment that you, the injured patient, received and his documentation. Doctor, isn't it true that Mrs. Jones showed up in your office on January 1st with the following complaints? Yes, I did. And isn't it true that you obtained a history? Yes, I did. And the history reveals X, Y, and Z. Isn't that true? Yes. Doctor, if you had learned on that very first visit that Mrs. Jones had a history of this particular condition, would that have changed or altered your plan of treatment? Now, the doctor has to answer that question. Why? Because the law considers him to be a medical expert. Even though he is an opposing witness, he is somebody that you have sued, I am still permitted to ask him questions. These are known as hypothetical questions, and the doctor is required to answer those questions. So, going back to the title that I raised in this video, can I go ahead and would it be beneficial for me to ask the doctor why he screwed up? The answer is no, it wouldn't. But there's plenty more I can ask the doctor during this course of a deposition, also known as an examination before trial. So why do I share this quick information with you? I share it with you just to open your eyes to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video not because you want to see the beautiful scenery of where I'm walking around, but likely you have questions about your matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.